is that true or not true?
True.
Did you enter your plea of true to count one freely and voluntarily?
Yes, ma'am.
And because it's actually true?
Yes.
So you never even made it.
I know.
So
That's just,
This is one of those cases where you can tell the judge is already frustrated before the hearing even really begins. Mr. Douglas wasn't on regular probation. This was deferred adjudication. That means he was given a second chance to avoid a conviction entirely. All he had to do was follow the rules. And instead of getting closer to freedom, he walked himself straight back into prison.
all right. Will your client waive the formal reading of the motion?
He will, Your Honor.
I didn't already have that, sorry. This is cause number 25, DCCR 0895. And Mr. Douglas, I have a motion to revoke your unadjudicated probation. This shows that you were placed on probation November 18th of 2025 for the offense of obstruction or retaliation, a third-degree felony, and that was a 3-year deferred probation. Is that correct? And this motion alleges that you violated your probation and count one only by failing to act in a courteous and professional manner, by incurring 3 new incident reports while housed at the Jefferson County Jail, including a physical altercation with another inmate on November 29th, 2025, which was the same date of your last hearing. And so
This is where it shifts from just probation violation to something deeper. It's not just that he broke rules. It's that he acted like none of it mattered. The judge even says it. You decided, screw it. And that moment says a lot. When someone believes they're already doomed, sometimes they stop trying altogether. But here's the hard truth. Jail behavior matters. Judges watch it. Parole boards watch it. It's a preview of how you'll act on the outside. And when she asks him, was that worth it? And he says, I don't know. That's not defiance. That's someone who doesn't seem to grasp consequences.
is that true or not true?
True.
Did you enter your plea of true to count one freely and voluntarily?
Yes, ma'am.
And because it's actually true?
Yes.
So you never even made it.
I know.
So
That's just,
yeah.
and I guess once you did that, you decided, screw it, I'm going to do whatever I want because I already know I'm going to get in trouble, because you've been acting like an absolute fool in our jail. I'm not sure 4 years is enough. I need to think about this for a minute. I mean, is it really that hard to follow the rules?
No.
You didn't want to get out? You did? You got a problem with showing yourself while masturbating to the female officers out there, don't you? You don't?
I ain't got no problem.
You don't have a problem? You just like to do it and you think that's cool to do that in front of them?
This part is honestly the most powerful. I really, really wanted you to succeed. You don't hear that often in court. She went back through his juvenile history. She gave him structure. She gave him ISF as an option. She warned him clearly, no more incident reports. 7 chances to stop. And every time, he doubled down. At some point, a judge's credibility is on the line too. If she doesn't follow through after repeated warnings, the system loses its authority.
Even though you know you're going to get written up and go to prison for that? Was that worth it?
No.
Have a seat in the jury box. I'm not sure that I'm going to accept this agreement. I'll hang on to it for now and then think about it. All right. So just for the record, and I've gone back to review the pre-sentence report just to remind myself of what was in that and kind of what got us where we are now. And Mr. Douglas, I hate this because I really, really, really wanted you to succeed. I really did. I wanted you to be able to go to ISF, but I can't not stick to my word. I told probation when you were here. I told you when you were here. No more incident reports before ISF or you're not even going to make it. And it has been 1, 2, 3, 4, 5, 6, 7. So since November 18th, you've been caught with looks like kind of a makeshift tattoo needle, we've got 1, 2, 3, 4 or 5 at least times when you have been exposing yourself while masturbating to the officers, spraying other inmates with disinfectant spray.
Notice something important here. She actually considered giving him more than 4 years. You can hear it. I'm not sure 4 years is enough. That means the plea deal may have saved him from something worse. But even in sentencing, she doesn't sound angry anymore. She sounds tired, disappointed.
Horse playing, smoking. I mean, it's just,
Judge, I certainly understand your thoughts about it not being enough time, especially with the incident reports you're having a problem with on all these people in the jail.
no, I think I'm going to go along with what you guys have agreed to. I just wanted some time to look at it. I'm just reminding myself of all, I mean, the fact that you got this in the first place, because we went through, I have it all marked off on this PSI, your juvenile history and the opportunity you were given now that you're an adult to change your life and just follow the simple rules. So I am going to, let's see. So I have documents here on this tablet that have your signature on them, but the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Rojas?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
Do you understand, if I go along with this agreement, that you're waiving any right to appeal?
Yes, ma'am.
State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Douglas is not competent?
No, Your Honor.
All right, Mr. Douglas, I'm going to find that you entered your plea of true to count 1 freely and voluntarily. Find that count true. Find sufficient evidence at this time to find you guilty. Something wrong. Find you guilty of obstruction or retaliation, a 3rd-degree felony. Sentence you in accordance with your agreement to a term of 4 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm going to hand you the trial court certification that shows this was an agreement that I followed, so you waived your right to appeal. I'm also going to hand you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. If you have any questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Rojas. And so today, just Mr. Douglas, just because you got time today does not mean that you still can't do better and change your life. Better you act in prison, the sooner you're going to make parole. The sooner you do that, you can get out, hopefully follow the rules and have the best life you can. You get in TDC and act like you've been acting in our jail, you're going to end up doing the whole 4 years. But you're eligible for parole in less than 2. In about 1.5 years, you're eligible for parole. And that's going to be 100% up to you. And I can assure you, you're not going to get it if you keep acting like this. All right? You can go back with the bailiff.
Yeah.
Thank you.
The final words matter. You're eligible for parole in about 1.5 years. That's 100% up to you. That's not a threat. That's a choice. For years doesn't automatically mean 4 years. But the way he acts inside prison will determine everything. This whole case isn't about one fight in jail. It's about a pattern. When someone keeps sabotaging their own second chances, eventually the system stops offering them. And what stands out most here isn't the sentence. It's that the judge genuinely wanted him to succeed. And he just couldn't get out of his own way.
Are they here still? Good morning. Are you Christian Kane? So, Mr. Kane, I want to visit real quick before we go forward. We were here when you were in custody and had a doctor visit with you, and I made a finding that there needed to be some treatment for competency restoration, and then you've made bond. And so we've got to make sure that you understand everything. Are you currently under any treatment through Spindletop or any type of psychologist or anything like that?
No.
Okay.
Last I had from my own personal doctor was a Valium, which is a very low barbiturate, which is to help control severe anxiety. It's so low that it's 10 times weaker, I like to say, than clonopin, 10 times weaker than Xanax.
So let me explain something, Mr. Kane. Because we have a doctor's report that says that there needs to be,
You didn't
Held
come
on.
See me, I waited for 2 months.
no, they did see you and they already made the report and I ordered that you go.
Why?
Well, because they're the doctors, I don't know. So, I'm sorry. What'd you just
In
say?
my opinion, sorry.
I didn't hear your words.
Made a fool out of it.
That's what I thought I heard. So here's what I'm going to do, Mr. Kane, because I've got to make sure that you're safe, that everyone in the community is safe. And at this time, I'm going to revoke your bond and find that you are at large
Victorian
with,
and early graduate.
and so I'm going to, that we already have that order in place for competency restoration. There will be no bond in this case. I'm making that finding based on that report, taking judicial notice of the court's file. You need to go back with the bailiff, sir. Yeah. Ms. Taylor? Melissa Taylor? Good morning. Are you Melissa Taylor?
Yes, ma'am.
What do you have on your,
Oh, this is my son Brandon Taylor.
uh-huh. Why'd you wear that this morning?
Because he's my entire world and he's messing me there.
Okay. Ms. Taylor, this is your initial, no, you were here before. Did you get someone hired?
Ma'am?
Did you get someone hired?
No, I have contacted 4 different attorneys. I have the printout paperwork. I've got all the information. They're extremely expensive. I've not been able to get the funds gathered for that.
Who'd you talk to?
I spoke to Brown
Where?
a month ago.
Where'd you?
Grab it in my phone.
Okay. Did you talk to some more since that last court date?
The last hearings.
Uh-huh.
You asked, you instructed me to get 3 quotes.
Mm-hmm.
That was what I did. And I can get that turned into you after,
Okay. If I test you this morning, you can have anything in your system? Have a seat in the jury box. We're going to text. See, Mr. Rojas, you have Christian Kane.
That's the one that is competent, but he bonded out. And you told me to set it,
Oh, okay.
but we've never had,
Yeah.
really had that yet.
And was ordered to
Yes, ma'am.
And he brought it up.
Yeah.
Christian Kane.
You mentioned Swindle.
Ms. Taylor, you tested positive for amphetamines, methamphetamines, and ecstasy. And so at this time, I'm going to find that that is a violation, obviously, of your bond conditions. And I'm going to raise your bond in your case to $100,000. Well, let me look at it real quick. I'm going to, let's see. In one of your cases, you're charged with assault on a peace officer, the other credit or debit card abuse. In each of those cases, I'm raising your bond to $100,000 in each case. If you make the bonds in those cases, you are ordered to wear a drug patch at all time, get it tested at the appropriate times, and then we will move forward with your case.
can I ask a question, please?
Mm-hmm.
Am I about to be arrested and,
Yeah, you're going into custody right now.
okay, I have a child.
You shouldn't be using ecstasy and methamphetamine. If you have a child, you can go back with the bailiff.
So I
Go back with the
have
bailiff
not.
right now.